Sometimes the truth has a price. That may be the lesson of a Virginia police officer who says in trying to do the right thing, he ended up paying for it. Of one man who confronted truth and consequences.
This is the Truth and Consequences podcast with Doug Poppa. From Las Vegas, Nevada, this is episode 77 for Sunday, December 19th, 2021. Robert Coache, spelled C-O-A-C-H-E, was wrongfully convicted in 2016 of more than 4 dozen felony charges, to include extortion by a public officer, bribery, misconduct by a public officer, and money laundering. In 2017, Robert Coache, a retired deputy state engineer with the Nevada Division of Water Resources, was incarcerated in Nevada State Prison and spent over 16 months confined until he was paroled. On August 18, 2019, Coache was discharged from parole. Coache filed a federal civil rights lawsuit in July of this year against the Las Vegas Metropolitan Police Department and the Clark County District Attorney's Office. In July of 2019, the Nevada Supreme Court, after reviewing Coache's case, ordered that the judgment of conviction on all 49 charges against Coache be reversed. Quote, "We are not convinced that a rational juror could reasonably find, beyond a reasonable doubt, that Coache committed the charged offenses based on the evidence presented at trial," unquote, 3 Nevada Supreme Court justices ruled. According to court records, the charges that led to Robert Coache's then conviction stemmed from a 2-year period starting in 2006, when Clark County prosecutors alleged, based on a Las Vegas Metropolitan Police Department investigation, that Coache and another man, Michael E. Johnson, then chief hydrologist for the Virgin Valley Water District in Mesquite, Nevada, orchestrated a bribery scheme to sell water to the Southern Nevada Water Authority. Johnson was indicted and convicted along with Coache. On July 14, 2021, attorneys representing Robert Coache filed a complaint in United States Court for the District of Nevada for violation of the 14th Amendment due process, violation of the 14th Amendment, detention without probable cause, and deprivation of liberty, failure to intervene, conspiracy to deprive constitutional rights, and violation of policy. According to a copy of the lawsuit that I obtained, among those named as defendants in the lawsuit for the wrongful conviction of Coache for the crimes of bribery, extortion, conspiracy, and money laundering, crimes Coache did not commit, are the Las Vegas Metropolitan Police Department, then Detective Nathan Chio, spelled C-H-I-O, who investigated the case and is now a lieutenant with the LVMPD, Colin Haynes, spelled H-A-Y-N-E-S, who was a senior financial intelligence analyst with the LVMPD, who was also involved in the criminal investigation of Coache, Clark County Deputy District Attorney Mark DiGiacomo, and Clark County Deputy District Attorney Sarah E. Overly, who prosecuted the case against Robert Coache. The complaint states that as a result of the misconduct of the defendants, Coache has sustained significant damages, including loss of his liberty, loss of his income, loss of his property, loss of his professional license and professional reputation, severe emotional distress, and many other forms of damage. The following are excerpts from the 38-page lawsuit. Coache's wrongful conviction was no accident. It was the direct result of misconduct by defendant LVMPD detectives and Clark County Deputy District Attorneys. No evidence linked the innocent Coache to the alleged crimes in any way. In fact, on November 14, 2018, during oral arguments held before the Nevada Supreme Court, when questioned, defendant DiGiacomo admitted that he did not have any evidence that Coache committed any of the crimes for which he was unlawfully convicted. The magnitude of such an admission by Defendant DiGiacomo, a high-ranking Special Deputy District Attorney, before the Nevada Supreme Court justices, that he pursued charges, prosecution, and the incarceration of Coache, knowing he had no evidence of guilt, cannot be understated. The LVMP detectives' conduct was overseen by defendant supervising officers who, upon information and belief, knew or should have known of the misconduct of the LVMPD detectives, lack of training, fabrication of crimes, false statements, and a complete lack of evidence. The Deputy District Attorney's conduct was overseen by defendant supervising attorneys who, upon information and belief, knew or should have known of the misconduct of the Special Deputy District Attorneys and Deputy District Attorney, malicious altering of court documents, false statements, solicitation of false statements, and complete lack of evidence. Like a volcanic eruption, the rarity of Nevada Supreme Court justices unanimously stating that no reasonable juror should have convicted Coache puts any interested party on notice that the instant prosecution was seriously flawed. For instance, in addition to Defendant DiGiacomo admitting he had no evidence of a crime, the state never charged the person, John Linetti, who supposedly gave the bribe to Michael Johnson, with any crime. Coache's wrongful conviction was ordered to be reversed by the Nevada Supreme Court on July 19, 2019. The convictions were subsequently vacated on December 2, 2020. Defendant DiGiacomo knew, as he admitted to the Nevada Supreme Court, that he had no evidence that Coache committed the crimes of extortion or bribery. Because the state failed to prove that Coache entered into any agreement with anyone to perform an illegal act, the state failed to prove any conspiracy by Coache. Defendant DiGiacomo called Defendant Haynes as a trial witness. Defendant Haynes is a detective with Defendant LVMPD and claimed to be a certified money laundering specialist. Defendant DiGiacomo had Haynes testify that Coache's financial activity was consistent with money laundering. Defendants DiGiacomo and Haynes knew that to constitute money laundering, the accused money must have derived from illegal activity. Defendant DiGiacomo knew that Defendant Haynes had absolutely no idea whether Coache ever received money from any illegal activity. Defendant DiGiacomo had LVMPD Sergeant Nathan Chio falsely testify that Coache had the authority to title water permits, and if he was a party to the Linetti agreement, he had committed a criminal offense. The truth, of course, well established by numerous witnesses, was that Coache had no authority to, quote, title water permits, unquote, and was not a party to the Linetti/Johnson agreement. It should be noted that Defendant DiGiacomo and Chio's investigative work was so inept that they did not know there is no such terminology as, quote, title water permits, unquote, with regards to the water rights process. Defendant DiGiacomo also had Defendant Chio read from Defendant's Exhibit O, an email prepared by an employee of the police department containing a hearsay statement about the case to support the preparation of subpoenas. Not only was the statement hearsay, but Defendant DiGiacomo also said in the presence of the jury that the information in Exhibit O was a summary of the facts from Johnson himself. Defendant Chio also testified that some of the words in Exhibit O were from the mouth of Johnson. Defendants DiGiacomo and Chio both knew that the truth was that the information in the exhibit was not from Johnson, yet they give the false statement to the jury. Defendant DiGiacomo was of course present throughout Coach's entire trial. Not only was DiGiacomo fully aware that he did not have the facts to prosecute Coach of the crimes for which he charged Coach, he could see he was unable to present any evidence to support the charges, which he later admitted before the Nevada Supreme Court. Once the government rested, and it was apparent to Defendant DiGiacomo that he had not presented sufficient facts to convict Coach, he had the duty to ask the court to dismiss the charges against Coach. But he did not do so. In failing to ask for dismissal of the case, DiGiacomo violated Coach's constitutional rights. Defendant DiGiacomo's clear fabrication of facts led the jury to believe that Coach had an interest in wanting the Linetti application granted. The truth was that Coach had no knowledge or interest in Johnson's agreement with Linetti or the Linetti permit. Defendant DiGiacomo substantially altered jury instruction number 12. Defendant DiGiacomo also substantially altered jury instruction number 15 in reference to the bribery statute. Defendant DiGiacomo knew and admitted to the Nevada Supreme Court that there was insufficient evidence to prove that Coach committed any of the crimes for which he was charged. On November 30th, 2016, Coach filed a motion for judgment of acquittal. As a result of Defendant DiGiacomo's vigorous argument against the acquittal, the court denied Coach's motion. Detectives Chayo and Haynes deliberately gave false and misleading testimony to the jury, with the intent to persuade the jury that Coach received a bribe to approve Linetti's water right application. Detectives Chayo and Haynes deliberately gave false and misleading testimony to the jury, with the intent to persuade the jury that Coach committed extortion. Detectives Chayo and Haynes deliberately gave false and misleading testimony to the jury, with the intent to persuade the jury that Coach received $600,000 as a result of bribery and extortion, then laundered that money. Defendant Special Assistant District Attorney DiGiacomo prosecuted a criminal case against Coach, knowing that Coach had committed no crimes. Defendant DiGiacomo did so by presenting false and misleading facts to the jury. Defendant DiGiacomo fabricated and solicited false evidence, including witness statements and testimony he knew to be false. Defendant DiGiacomo, without any legal authority, substantially altered multiple jury instructions to maliciously, purposely, and deliberately deceive the court and mislead the jury. Had officers and agents of the Las Vegas Metropolitan Police Department promulgated appropriate policies, then the violation of Coach's constitutional rights would have been prevented. These practices and customs, individually and/or together, were allowed to flourish because the leaders, supervisors, and policymakers of the Las Vegas Metropolitan Police Department directly encouraged and were thereby the moving force behind the very type of misconduct at issue by failing to adequately train, supervise, and control their officers, agents, and employees in the areas identified above, and by failing to adequately punish and discipline prior instances of similar misconduct, thus directly encouraging future abuses like those affecting Coach. Now my closing comments. Wow. I was going to say that I was wondering why Robert Coache's lawsuit was not covered by the Las Vegas media. At least I didn't see it anywhere. However, I knew the answer to my own question. Apparently, the local media may not want to give any bad press to the Las Vegas Metropolitan Police Department and the Clark County District Attorney's Office. After all, it's election year in 2022, and Clark County Sheriff Joe Lombardo, who runs the Las Vegas Metropolitan Police Department, is running for governor of Nevada, and Steve Wolfson, Clark County District Attorney, is running for re-election. Nothing like keeping the local community in the dark. My final remark: police and prosecutorial misconduct is a threat to individual freedom and liberty. Thanks for listening, folks, and remember to subscribe to Truth and Consequences with Doug Poppa, video podcast available on YouTube, Facebook, and Rumble, audio podcast on Spotify, iHeartRadio, and other platforms. Please support my independent investigative journalism at paypal.me/Doug Poppa. Contact at truthandconsequenceswdp@gmail.com.